Hello, I'm J. Jermaine Bay with Elodium Moorish Pradium, Ante, Colorado. The acronym is AMPAC. I am the Chief Judge of Consular Court. Today is Class 78. Class 78. What did we learn in Class 77? Well, we're still taking a deep dive into the preamble of the Charter of the United Nations of 1945. Right? We're starting to break down some of the words that way we understand the philosophy of the Charter. Right? The preamble tells you a lot about what you're about to read, right? So the preamble really gets into what's called human rights. And how do people get their human rights? Well, first they must understand the conditions. Well, it's not necessarily the conditions of their status or how they're being treated, but the conditions based upon contracts. The conditions set up the provisions, the instructions of the contract. Your obligation, based upon your ancient mother fathers, to go back and read what did your ancient mother fathers put in place based upon contracts, right? So the charter is set up for human rights, and human rights is based upon the ancient, right? The ancient times, the ancient common law, the common law, which is the common sense of law, mother's law, nature's law, right? Amongst the people, all right? So what we're learning is this is all about human rights, but the human rights is about what? Establishing conditions, right? And then having the obligations based upon you trying to get your justice and your peace. But what gives you your justice and your peace? Now the charter tells you in the preamble, you have to understand treaty rights. You have to understand international law. See, it's the yellow brick road for all the Moors of planet Earth, right? Who have been given a nom de guerre, right? Who have been given a misnomer, brand, or a title of who they are as a people. So once you understand who you are, now you must understand what did your ancient mother and fathers put in place. For you go back and read and comprehend on how to enforce those principles, those rules, right? Those laws, that international law. And what is international law? Moroccan law, right? International law is Moroccan law. Why do I say that? Because the charter was founded where? In Morocco. Which makes it part and parcel to Morocco. Who had to give the grant for the charter to exist? France. But France was acting on behalf of who? The Sultan. And the Sultan was acting on behalf of who? Moors. So it is Moorish law. It is Moroccan law because France enacted a charter based upon what? Moroccan territory. Isn't that what the Treaty of Fez of 1912 says? It was the obligation to establish a new regime in the Moroccan territory. So the charter itself says international law. But that international law is based upon what treaties? Moroccan treaties. That must be understood, right? So as you're reading the preamble of the charter, and it keeps talking about the principles of treaties and international law. You notice they put the word treaty first, then the word international law. You see how they put it in sequential order? The treaty comes first and then international law. There is no international law without the treaty, and there is no treaty without Moroccan Moors establishing these treaties under our ancient principles. That must be understood. You must watch the way they write and scribe into contracts. They put things in sequential order, but you're not recognizing it. How they write, they put things in sequential order, right? So like in the rights of indigenous people, Article 5, they'll say political, legal, right? What's the next word after legal? Economic, social, cultural, right? So the first word they put is political. What is that? State. And with the state, you have legal. What is legal? Your laws, right? And through the laws, now you can enforce what? Your economics, your social and cultural. But social and cultural comes last. Your culture is protected by the state and its laws. But without a state, you can't protect your culture. So they always put words in contracts that set up in chronological order so you understand what comes first, right? But when they established the charter, what's the first thing they put in the charter? We the people. First words. Well, who are you as people? Then the next thing they said what? It's about human rights. They're still talking about people. Second thing they talk about human persons. Then they start talking about what? Men and women. Then they said of what? Nations. The word nation, i.e. state, came last. The people set up the nation. The people are the nation, and the people set up the state. They put it in chronological order, right? So as we're getting into class 78, keep in mind in class 77, we talked about the word proverb, right? Proverb, compound word, right? Verb. So what is Proverbs chapter 4, verse 7 about? It's about an action. Noble Drew Ali said what? He wanted active Moors, not passive Moors. Yeah. So Proverbs is about what? A forward action, right? It's not about marching in place. Your left, right? It's about moving forward with that motion and not marching in place. But the first thing you have to understand is, who are you? You're not Moorish American. You're Moroccan. So Moroccans got to move forward. Noble Drew Ali was a what? A prophet. Prophet. What does prophet mean? He was prophetic, right? He was doing what? Predicting the future. He was using foresight. But where did his foresight come from? He was reading the treaties. You can tell how he put together a constitution. What was the first thing Noble Drew Ali did? First, he recognized himself. He says, I'm Moroccan. He said, yeah, I got a little bit of so-called Indian in my family, but that's what they put on a document. I ain't Indian. I'm Moroccan. He said, we're descendants of Moroccans. What was the second thing he did? He went out and enacted a constitution, right? So he recognized himself. Islam, myself, law and master. But who are you? He said, I'm Moroccan. I'm a descendant of Moroccans. What's the next thing he did? Enacted a constitution. But unfortunately, he did not ratify it and deposit it, right, and promulgate it in accordance to international law. Keeping in mind that the Treaty of the Act of Algeciras came out in 1906. Treaty of Fez came out in 1912. Noble Drew Ali comes out in 1913. So he had an obligation to maintain the provisions, the general provisions of the Act of Algeciras, Chapter 7. In its Articles 120 to 123, he had an obligation to check those boxes, just like every other Moor on planet Earth. That must be understood. So the Act of Algeciras comes out in 1906. Noble Drew Ali comes out in 1913. How many years is that? 7. So the first 7 that Noble Drew Ali came to us and said, you're Moroccan. That's the first 7. That's the circle 7 versus self. Then you can talk about checking the next boxes of the triple principle, which is sovereignty and independence, which is what? Statehood for who? The nation. What's the second box? Interior domains is what? Laws and judges, your council court to protect the people in the state. And last but not least, economic what? Liberty without any inequality. That's the finance. That's the economics, right? That means now you're in governance. You're bringing in the taxes, etc. But the money is only a byproduct of a job well done of you first recognizing yourself. Then getting into statehood. You must understand the steps that Noble Drew Ali took. That's very important to know thyself. Let's get into the class. As you know, ANPAC always opened up the Constitution. Noble Drew Ali opened up with a Constitution, right? But he also told us the other half hasn't been told. This is the other half, to finish what he started. He was a prophet, P-R-O, prophet. What does pro mean? Forward. He was forward. He was a forward thinker. He was a critical thinker. But where did he get his critique from? Treaties. You must understand what's happening. Okay, so we've got the Constitution of ANPAC up. All the Moors would need a constitution and their own individual autonomous state throughout the empire that outlines your latitude, longitude of the state. But the question is what's the name of the nationals of your state? Are they Moroccans or Americans? Well, the treaty says what? Moroccans. So you're entitled to your own self-determination, but you're not entitled to your own truth. So truth is based upon the definition of principle. The Moors say we have principles. We say, what are the 5 points of light? What are the principles? Love, truth, peace, freedom, then justice. You got to put all that together. We got to talk about truth today. Continue on this same platform of truth, because the truth will set you free. All right, so let's continue. Okay, so we're reading over the Charter of the United Nations. We're getting into the preamble. We're going to finish that up, right? So let's go ahead and get on into it. Charter was established in 1945. We already know that it's about the people, right? It's about the people. We are the people, and who are the people? Moroccans, specifically speaking, geographically speaking, about this subsection of the empire, right? We're Moroccans. The people must be known, the parties must be known to the contract, and the contract says only Moroccans can enforce the treaties. All right? Now let's get into the second part. Okay. So we already have the mother read the preamble. I'm going to go ahead and jump on in and just finish on with the interpretations. Keep in mind our mother will not be here today. Good mother Maat, she's a little under the weather today, so she won't be here to read. What we're going to do is we're going to have good brother Speaks Bay go ahead and help us out today, so we appreciate that, good brother Speaks Bay. All right, so right here in the preamble of the Charter of the United Nations, it says, and for these ends, to practice tolerance and live together in peace with one another as good neighbors. So all states are neighbors of each other. And to unite our strength to maintain international peace and security. And to ensure by the acceptance of principles. This is a contract. So we all must accept principles. Right? So we talked about Proverbs chapter 4, verse 7 says what? Wisdom is the principal thing. But the principle was spelled with what? P-A-L, right? So this is principles, right? Principles versus principals, right? Proverbs chapter 4, verse 7 says principals, P-A-L, right? This says principles. So what are the principles about? It's about the common law, mother's law, ancient law, right? What is the principal? The principal is you, right? You are the thing that must have wisdom in order to now go and enforce what? The principles. Once you understand the principal, you, the peak of you, the head of you, the wisdom of you, the wise dome of you, then you set forth the principles based upon your ancient mothers and fathers. All right? You must understand the difference between principal and principles. Okay? Let's take it from top. To practice tolerance and live together in peace with one another as neighbors. To unite our strength to maintain international peace and security, and to insurance policy, ensure by the acceptance of principles and the institutions of methods, armed forces shall not be used, save in the common interest, and to employ international machinery for the promotion of the economic and social advancement of all peoples. Right? So everything is, whoever signs on to this contract, as soon as you have a state and you accede to this contract and become a party to it, immediately you're responsible for what? The acceptance of principles and maintaining the peace and security. Well, let's say we have a more state and we say, well, we don't want to accede to the charter. Well, you still have to accede to it anyway under acquiescence, because as soon as you have the name state, the charter acts as an HR department, as a compliance department to oversee all states, right? That way all states understand the compliance of how we get into diplomatic relations or how do we settle disputes. So either way, you've already acquiesced or consented to this contract. Keeping in mind, what is the Charter of the United Nations? It is part and parcel to Morocco. In theory, it is Moroccan law. It may not say Moroccan law because it's general language in here. It's not going to talk about Moroccans. It's not going to talk about Germans. It's not going to talk about Russians. It's not going to talk about Brazilians. right? It's speaking in general language for all states. But this charter, according to the Act of Algeciras of 1906, Article 123 gave France, the Sultan, and Moors powers over what? All treaties, conventions, and arrangement. This is what? An arrangement based upon a convention of states coming together to accede to it. This is Moroccan law. This is Moorish law that you're reading. You must comprehend that. So you're acceding to something that your ancient mothers and fathers already set up the principles about. These are the principles that they're just doing what? They're regurgitating. It's redundancy that they just put into a charter, but these are the words that come out of our own treaties. Okay, let's continue. Have resolved to combine our efforts to accomplish these aims. Accordingly, our respective governments, through representatives assembled in the city of San Francisco who have exhibited their full powers found to be in good and due form, have agreed to the present Charter of the United Nations, and do hereby establish an international organization to be known as the United Nations. So what's happening? Do you see what this last paragraph says? Do you see what happened? These were a set of instructions. They were checking boxes. What do they say? Every state that came to the table to sign off on this contract, this arrangement, this convention had to have what? Listen. They, who? The states exhibited what? Their full powers. And their full powers are found to be in good and due form. Have the Moors exhibited their full powers? Through what? Statehood, constitution, and sent their what? Authorized authority to sign off on any treaties, any type of contracts? We haven't had the proper authority. We were not found in what? Good form. We did not have full powers to enact even our own treaties. We couldn't enforce our own treaties because we were never found in good form, in due form, right? What do they say? We must be found in what? Full powers must be found to be in good and due form. How do you prove that? With what? Proper written instruments. Not your mouth, not your chanting. You must have what? Governmental credentials from your state. That's what's found in good and due form, along with your constitution. Okay? All right, let's go ahead and get into it. Chapter 1. Okay, good brother speaks.
Chapter 1, Purposes and Principles.
Pause. Everything's in the title, right? You never read past the titles, Morris. We have a bad habit. We pronounce the title and we zip right past it. We go right into the reading of the text, right? What does principles mean? We all think, oh, I know what principles mean. Okay, what does it mean in law? Right? Okay. Brother speaks.
Principle, a fundamental truth or doctrine as of law, a comprehensive rule or doctrine which furnishes a basis or origin for others, a settled rule of action, procedure, or legal determination, a truth or proposition so clear that it cannot be proved or contradicted unless by a proposition which is still clearer. That which constitutes the essence of a body or its constituent parts. Term 107. That which pertains to the theoretical part of a science. Himmler versus Richard Parish School Board.
All right, case law, right? So principle, Black's Law Dictionary, 4th edition. What is principle about, right? Not principal, principle. Principles. Principle, a fundamental truth. But what's the first fundamental truth? Do you see the compound word? It's about the fundamentals of truth. Right? It's about what? The foundation of your mental truth. It's about your mental foundation. What is your mental foundation? Do you know yourself? That's the first truth. Self. It's Islam. I, self-law, am the master. It's the mental foundation of truth of yourself. And once you understand yourself, then you can check the next box and understand what are the laws about as it relates to you. Why do you think black people keep seeking civil rights? You know why? Because that's their truth. They think they're black, and black people seek civil rights, which is statutes of the United States International Organization. They're statutes, the revised statutes of a constituent chartered state, i.e. a corporation of the United States, commonly known as the state of Alabama, the state of California, the state of Illinois, etc. People, they're fundamentals, right? So black people have been taught that their mental foundation, or the foundation of their mental truth, is that they're black. So what do black people seek as a remedy? Civil rights. Right? Okay. What do the Moorish Americans keep saying they're where they get their rights from? Enforce the Constitution of the United States of America. They say enforce the Supreme Court decisions, res judicata. They say enforce the statutes of South Carolina, enforce the statutes of North Carolina, enforce the statutes of any of the several union states. Why? Because the Moorish Americans' mental foundation, or the foundation of their mental truth, is saying Moorish Americans are what? Americans. So when you think you're American, you keep trying to enforce an American Constitution. You keep trying to enforce American statutes. That is the foundation of your mental foundation. But when you know you're a Moroccan, now all of a sudden you're enforcing what? Moroccan treaties and Moroccan laws. And what is a Moroccan law? The Charter of the United Nations. What else is Moroccan law? All our treaties. What else is Moroccan law? Your own constitution that you enacted on your own and ratified, deposited, and promulgated according to international law. That's what Moroccans do. Because that's our mental foundation. That's our foundation of our mental status. What status? Political status. You see how that works? See the building blocks? We've delayed our own justice because we didn't know who we are. That is the truth. That's the first block in the circle 7. Remember I set up the 4 sevens, right? Under Proverbs. I said Proverbs about what? The 4 circle 7s. But the first circle 7 was self. Because whoever you think you are, that's going to be the level of where you think your remedies are going to be found. You must understand there's nothing higher in law than international law. That's the peak of law. But international law is what kind of law? Moroccan law. You'll understand that as you keep studying, you will see the foundation of it. We're talking principle. A fundamental truth or doctrine as of law. A comprehensive rule or doctrine which furnishes a basis of origin for others. A settled rule of action, procedure, or legal determination. A truth or proposition so clear that it cannot be proved or contradicted, unless by a proposition which is still clearer. You see what's happening? They're telling you a lot right here on these couple sentences. You got to break it down. What are they saying? What does the common sense tell you already? Okay, once you know yourself, now you know the truth. Okay? Now once you know the truth, you can go and enforce some laws. Well, what laws? Moroccan laws. Not civil rights, and certainly not the Constitution of the United States of America, because you ain't American. And once you understand yourself, you understand the laws, then now you start understanding the rules of engagement based upon those laws. After you understand the rules, then you set up the procedures. What procedures? On how you deal with civil and criminal disputes. Because there's procedures set up what? Legal determination. What is legal determination? That's when something is adjudged. Adjudged. One word, adjudged. Means it's settled. By who? The competent court. But if you don't know yourself, then how do you know the laws you're supposed to be using? And if you don't know the laws you're using, that means someone can just simply set up any rules they want. And once they set up the rules, then they're going to set up the procedures of the court they want you to go to. And once they send you to the court they want you to go to, by their legal determination, you're guilty. You were guilty before you walked in. Why? Because you were a fraud walking through the door. What made you a fraud? See, you was already a liar when you walked into their courtroom because you were lying on yourself because you don't know yourself. Yeah, Your Honor, you know, us black people and you know, us minorities got it bad and we as colored people need to stick together as African Americans. And, you know, we just got to keep hope alive. Well, dang, how many nationalities, how many titles do we have? Are we black? Are we minorities? Are we colored? Are we African American? Even the white people don't know what to call us. Do you remember when Trump said, "What do I call y'all?" Jesse Jackson said we're African Americans. Farrakhan said we're black. Who are we? Martin Luther King said we're what? Negroes. Moorish Americans said we're Moorish Americans. Who are we? Because the sooner we know who we are, the sooner we can start enforcing the fundamental truth. Once we understand the fundamental truth of self, we can start enforcing laws, rules, procedures, and adjudications. Anytime we have a dispute. But guess who we got the first dispute with at this time? Ourselves. Listen. Principle is based in truth. Listen. Principle, a truth, or proposition so clear that it cannot be proved or contradicted unless by a proposition which is still clearer. You see, you can have a truth, but sometimes somebody else's truth makes your truth subordinate. In other words, some people can have facts, and everybody's entitled to their facts, but you're not entitled to your own truth. But how do you bring the full truth? How do you present something that is clearer? How do you present something that's the truth, right? How do you present something that's the truth that is clearer truth? How do we do that? It's called proper written instruments. The proper written instruments are called exhibits, right? The exhibits will set you free. If in fact those exhibits are based in what? Truth. About who you are and what part you play in that truth. Based upon the law that sets up what? The rule. And the rule sets up the procedure, and it now dictates a legal determination of something being adjudged. So how do you make something that's already truth that's clear, right? How do you make something that's already truth? If something's true, it can't be defeated, it can't be contradicted. But sometimes somebody else might have some truth that supersedes your truth. You see what they're saying here? Let me give you an example. Here we go. Here's the Constitution of the United States of America of 1789. And here's the Constitution of the United States of 1871. Act of Congress, 1871. So they both have similar language. But the United States of America right now and the United States International Organization will tell you they have jurisdiction over us, right? And that's the truth. That's the truth. They got jurisdiction over us. Who's the us? Black people. Negroes, blacks, coloreds, Americans, i.e. NABCAs. That's the truth. But when you read the well set up principle of law, the principle is the truth. And if you know how to enforce understanding yourself as Moroccans say, I have a clearer truth than your truth, United States of America. And what's the clearer truth? Okay, then what? All treaties made or which shall be made is what? Shall be the supreme law of the land. Well, who can enforce treaties? Only Moroccans. Moroccans in the possession of what? A proper written instrument called what? Constitution, state. And then they have what? Full authority. And they're found in good and due form because they got governmental credentials from the state. And that Constitution has been ratified, deposited, and promulgated in accordance to international law. And now the treaties become what? The supreme law of the land, which makes it a clearer truth. This is principle of law. Right? Let's go back to principle. I'm going to keep going back and forth to this, so you got to keep up with me. So the principle is about what? Fundamental truth. That sets up the laws, the rules, and then the procedures, and dealing with civil and criminal courts. So they got a truth that right now is clear. But the Moors, what type of Moors? Moroccan have a clearer truth. Once they know themselves and know how to make a proper claim to their estate. Listen. What happened next? Here's a clearer truth. Here's the Treaty of Peace and Friendship. This is principle. What's principle based on? Fundamental truth. About what? Laws, right? And those laws set up what? Procedures, right? Let's go back to it. The principle sets up the truth. That sets up the law. And then the rule of law that sets up the procedure for civil and criminal disputes. Okay, so the United States says, okay, we got a constitution over the NABCAs, but when the NABCAs find out who they are, now they enact their ratified, deposited, promulgated constitution. Now all of a sudden the treaty, in which the treaty right now is giving the United States of America powers over NABCAs. That's their truth. But when you read the Treaty of Peace and Friendship, now you have a clearer truth because now you know that they're subordinate in the contract. They're subordinate to what? Morocco and Moroccans. That's the clearer truth because they signed this contract. This is the proper written instrument that now you use in what? The procedure of what? Civil and criminal dispute in court. This is the contract they signed. Who can enforce this? Black people can't enforce it. Moorish Americans can't enforce it. Why? Because only Moroccans can enforce it. So your truth is fundamental to understanding self and then enforcing the law, then the rule, then the procedure. The procedure of what? Civil and criminal courts. You see what they're telling you about principle? Listen, what else do you enforce? Listen, here's George Washington's letter. This is considered what? Executive order from their president, George Washington of the United States of America. What did George Washington do? He deposited a copy of his constitution with Sidi Mohammed, the Sultan of Morocco. Why did he think he needed to deposit his constitution with Sidi Mohammed? Because Sidi Mohammed was doing what? Checking for what? To see if he was in what? Good and due form. To see if he had what? The representatives based upon a state. And how do you have a state? You got to have a constitution. And then he turned around and enclosed a copy that's called depository with who? The sovereign. He's following instructions. So this is clearer truth. When Moroccans enforce and say, see what George Washington did? George Washington deposited his constitution of what? The United States of America, not the United States. United States of America is the name on the contract of their constitution and on the treaty. And George Washington deposited a copy of his constitution with the Sultan. It's called ratified, deposited, and promulgated, following instructions. That's the clearer truth. Listen. So what happens next? Here's the treaty of 1836, right? When they renewed the treaty 50 years later, 1787 to 1836, 50 years. So now the United States of America renews the treaty. And here's all their ratification, depository, and promulgation. They signed the contract. This is the clearer truth that they don't have dominion or jurisdiction over who? Moroccans in Morocco. But they got jurisdiction over Nafkas. But they don't have jurisdiction over Moroccans. Here's the clearer truth. 1880. Treaty of Madrid. United States of America and the United States became a party to it. They became subordinate in the contract. But they remain superior in it when we acquiesce. When we acquiesce and consent to be in Nafkas, they turn around and have a superior position under the status of what? Jacob. So Jacob now is he's now ruling over who? Big brother. It's when little brother Jacob is ruling over Esau. Esau is big brother. So now little brother's being ruled by who? So should I say big brother's being ruled by little brother? Who's little brother? It's Jacob. Right? You ever heard of Jacob the jeweler? Right? And all the Moors, i.e. the Nafkas, are going to Jacob the jeweler. Buying diamonds that already belong to them. So this is clearer truth of principles of law that set up the rules and procedures of civil and criminal jurisdiction. And right now, according to these treaties, the United States of America gets to maintain civil and criminal jurisdiction over Nafkas. But they do not have civil and criminal jurisdiction over Moroccans that have restored the state under Udi Posidatas jurisdiction. What else under principle? 1906, we're building up. Here's another treaty that the United States of America and the United States signed, making themselves subordinate in the treaty. But then the Moors acquiesce and consent and let the United States of America have civil and criminal jurisdiction over us as what? Nafkas, Negroes, blacks, colors, and Americans. But the clearer truth, because this is truth that they have jurisdiction over us while we acquiesce and consent. But as soon as we stop acquiescing and consenting, we say, no, we reject and renounce any naturalized status with the United States of America. Now we pledge allegiance to our Moor state. Immediately you become superior. You become Esau again in your rightful place. That's the clearer truth. Listen, that's 1880. Building up. Excuse me, that was 1906. Now we come to 1912. Treaty of Fez. It's a treaty that gave France dominion over the entire Moorish government. How did France end up with jurisdiction? Because the Sultan gave it to them. How did the Sultan end up with it? Because the Moors acquiesced and allowed a conqueror, i.e. the Ottomans, to come in and conquer our land after the Romans left. Right? So the Romans came in, right, during the Punic Wars, right? Punic Wars, right? 1 and 2. Right? So Scipio Africanus comes in. He defeats the Moors, Hannibal. He renames the land what? Africa. We got conquered then. Then the Ottomans came in and kicked who but? Constantine and his crew. The Ottomans just kept on going, taking over the Moorish Empire. Because we have been conquered. So we acquiesced to a conqueror. Well, our land got annexed. That's several different dynasties of different nations coming in and ruling over our land and resources. So now France is acting as a power of attorney because the Sultan was acting as a power of attorney over the Moorish Empire. Think about it. How could France turn around and tell the Sultan of Morocco in 1956, so Sultan, you telling me I can't have the pen, Sultan? This is France talking. You saying I can't keep the pen? So France tells the Sultan, well, you can't keep it either. We're going to put it in a neutral position. How could France tell the Sultan he can't have back his own pen? You know why the Sultan couldn't have his pen back? Because France was calling him out saying, you in the same status as me. We were both trustees. We were both managers. Neither one of us were Moors. So how do you, Sultan, have the audacity to tell me, France, what to do when you yourself, Sultan, ain't nothing but a trustee and a manager over the Moorish Empire? And that's why the pen was left in a neutral position. Excalibur. Because only the true heir can pick up the Excalibur and use it. France couldn't use it, and neither could the Sultan, because the Sultan is an Ottoman, i.e. from Turkey, Persia, etc. So now in 1956, this treaty becomes non-obsolete, right? Becomes obsolete. Null and void. That's what I meant to say, null and void. 1956. But before it became null and void in 1956, what happened? Okay. Charter of the United Nations was established in 1945 by France. Along with who? The United States of America. So France and the United States of America enact the charter because they were the last two Christian powers who have their names still tied to all the Moroccan treaties in 1945. They were the last two. Right? So what happens next? Now the charter is established by France and the United States of America, but France has the real power of the pen. Okay? What happens next? What am I looking at right now? Principles. This is law. The charter is law. International law. That set up what? The rules and the procedures to deal with what? Civil and criminal disputes. HR compliance. Listen. So what's the next principle? Okay. United Nations comes out with what? Universal Declaration of Human Rights. These are principles that set up laws regarding what? Human rights. And after you understand the laws, you set up what? The rule of procedure of civil and criminal jurisdiction courts to deal with disputes. That's called principles. What happened next? That's 1945, right? 1948. So Universal Declaration of Human Rights comes out in 1948. What comes out next? France takes the United States of America to court. 1952. 7 years after the charter established. 7. So they took them in 1950, but they got the judgment in 1952. 7. 1945 to 1952. 7 years. Right? And what happens? These become principles. What type of principles? Okay, listen. Go back to the definition of principle. All International Court of Justice cases are what? Settled rule of action. That came from what? The legal determination of the judges' order, judgments, and advisory opinions. So the case was adjudged based upon the law, rules, procedures in the International Court of Justice that set up after that, after the judgment came out, it became res judicata. It's called now settled rule of action to settle dispute, which set up what? Principles that came out of this case in 1952 of what? France versus United States of America. And the International Court let out secrets that are principles of law, and they did what? So you go to page 202, right? The Moors know about this already. Page 202. On page 202, International Court of Justice lets out the secret. How Moors get their rights. Okay, brother, good brother, speak. Let's go ahead and read this paragraph.
In the absence of any treaty provisions dealing with this matter, it has been contended that a right of assent can be based on custom, usage, or practice. It is unnecessary to repeat the reasons which have been given for rejecting custom, usage, and practice as a basis for extended consular jurisdiction, and which are largely applicable to the right of assent. It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to United States authorities can readily be explained as a convenient way of ensuring their incorporation in the ministerial decrees binding upon the consular courts. In that way, and in that way only, could these laws be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised.
Thank you, good brother. So what did we learn here in the International Court of Justice based upon what? Listen. Principle of well-settled principles of the rule of action, the International Court of Justice instituted what? Fundamental truths based upon the international law of treaties that set up the rules and procedures of the civil and criminal jurisdiction of the legal determination of a case. So you go back now to the case, and the first thing you start seeing right now is in the absence of any treaty provisions. So Moorish Americans are what? In the absence of treaty provisions. Why? Because we didn't understand the Treaty of Madrid, 1880, Article 15, paragraph 1 says, first you got to come back to Morocco and understand you're Moroccan. Then they tell you, okay, once you know you're Moroccan, Moroccan, not American, you can enforce, what about Moroccan? Okay, now you can enforce what type of laws? Moroccan laws, not American laws. Why do Moors keep saying we're Aboriginal Americans when we're Moroccans? You can't enforce a treaty saying you're American when the treaty says it's Moroccan law. But once you understand who you are, then you can enforce what? Moroccan laws, right? Moroccan what? Laws. Okay, let's go back to principles. Under principles, you got to understand the fundamental truth of self being Moroccan, so you enforce what? Moroccan what? Laws. Which now set up the rule and the procedure. What's the rule and procedure of the International Court? What did the International Court of Justice tell us in 1952 for who? Moroccans. What did they say? Listen, this is too easy. Okay, so now they're going to tell you the rule. They give the Moors the answers to the test. In 1952, they say what? About jurisdiction. Moors are always talking about jurisdiction. All right? So then International Court sets up the rule based upon the law. Then they set up the procedure, say, it is, however, necessary to point out the very large number of instances in which Moroccan laws are referred to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees, meaning court decrees and Moroccan law, legislation, and Moroccan orders and judgments binding upon the consular court. So whose obligation was it to enforce laws? It was binding on the consular court. Whose consular court? Moroccan consular court. ICJ said it's the Moors' obligation to enforce these Moroccan laws. And then they turn around and say what? So once you enforce the laws to the consular court, it is what? In that way, and in that way only, could these Moroccan laws be made enforceable as against the United States nationals, so long as the extended consular jurisdiction was being exercised. So they turn around and tell the Moors in 1952 and tell us principles of law based upon the fundamental truth of who you are. You can enforce the laws the rules and the procedures of the court to enforce civil and criminal jurisdiction. Against who? The United States of America. The United States, their citizens, and their more subjects. Proteges. That's principle. What else about principle? Okay. What else happened about a principle? We're talking what? In principles, they say principles are what? It's truth that's clear, cannot be contradicted. However, another truth can be clearer that beats what you think is your truth. So the truth is the United States of America and the United States International Organization has jurisdiction over NAFTA. That's the truth. But the clearer truth is that your treaties are supreme, according even to their constitution, much less yours and international law. Listen, so what does the United States do next in 1956? So they leave the International Court of Justice in 1952. What do they do next in 1956? They pass a legislation bill. Okay, good brother, speak. Let's go ahead and read that title.
United States statutes at large containing the laws and concurrent resolutions enacted during the second session of the 84th Congress of the United States of America, 1956, and proclamations. Volume 70, Annual Report, Public Law, 856, Chapter 807, page 773 through 774. Joint resolution.
So what's a joint resolution? That's when the House of Representatives, such as right now in the year 2022, who that? Nancy Pelosi. And then the Senate, right? What's the Senate? Who's overseeing the Senate right now? Yeah, Mitch McConnell, who else? And Schiff, right? So they got together back in 1956, not those personalities, but their offices of the Senate and the House of Representatives got together and put together a joint resolution that said, we got to relinquish jurisdiction in Morocco. 1956. This is the principle they set up. Right? But you got to listen carefully. So in this joint resolution that the House of Representatives and the Senate put together, they said approving the relinquishments of the coastal jurisdiction of the United States in Morocco. Ooh. Right? But listen, see how they're fooling you? This is what Moors get caught up in this title, but Moors don't read. They pronounce words and don't comprehend what they're reading because they get caught up because they skim too fast. Listen, they said, oh man, see, the United States of America approved the relinquishment of coastal jurisdiction of the United States in Morocco. See, they let go jurisdiction. They don't have civil and criminal jurisdiction over Moors no more. That's what the Moors ran off and said. But they didn't read the rest of it. Yes, the House of Representatives and the Senate got together and put together what? A bill. But a bill is not law. It doesn't become law until their president signs it into law. He must ratify it. Until then, it's just a bill. It's a bill of consideration. But it has not been signed into law. This isn't law. This is a bill that's been sitting on the president's desk since August 1st of 1956 as a bill that's never been signed into law by the president's office. Listen, go ahead and read it, good brother, so Moors can have a general understanding of what I'm talking about.
Approving the relinquishments of the consular jurisdiction of the United States in Morocco. Whereas the laws of the United States invest the ministers and consuls of the United States in certain countries, including Morocco, with judicial authority, so far as the exercise of the same is allowed by treaty with such countries and in accordance with usage in such countries. Period.
Stop right there. Pause, good brother. So right here, they say they approve the relinquishment, then they turn around as an oxymoron and say, what? Whereas the law of the United States invests the ministers and consuls of the United States in certain countries, including Morocco. See, now they're being specific. They're calling the party out. With judicial authority, so far as the exercise of the same is allowed by treaty. So their judicial authority is allowed by what? The treaty. But see, more up here read, oh man, they relinquished jurisdiction. But if you kept reading, they said they still got judicial authority allowed by treaty. Why? You'll find out later on as you read that this was just a bill. Because the real law was what? The treaty. They tell you what the real law was, the treaty. But this is just a bill, not law. It ain't been signed yet. It's still sitting on the desk of the United States since August 1st, 1956. Let's keep reading, good brother. Whereas,
And whereas the consuls of the United States and Morocco are permitted to exercise jurisdiction over American nationals.
pause. Moorish keeps saying we're Moorish Americans. Moorish said we Moorish Americans. Who do you think they're talking about? They already gave you a clue. Look, they said what? Including Morocco, in Morocco. Then they turn around and say over American nationals. So you're talking about Morocco, then they mention American nationals. So who are American nationals? Nabcas. Negroes, blacks, colors, and all Americans. And guess who keeps saying they're Americans? Moors. So the United States got jurisdiction over Americans who have failed to return to Morocco, who are still naturalized under the Naturalization Act of 1870, still naturalized under the 14th Amendment of 1868, and in violation of the Treaty of Madrid of 1880, Article 15, paragraph 1 says that any subject of Morocco, that's you, that's been naturalized in a foreign country, that's you, must choose between the entire laws of the empire. So you have an obligation to return to the entire, not halfway, because ain't no such thing as halfway crooks. Ain't no such thing as halfway nationals. Ain't no such thing as halfway statehood. Noble Ali said what? The other half hasn't been told. He wanted you to take it full circle. You still only halfway. So what did the United States turn around and say? We still got jurisdiction, even in 1956, because the International Court of Justice said that the United States of America could hold on to a limited jurisdiction over acquiescing Moors. Take it, brothers. Take it from here.
Whereas the consuls of the United States and Morocco are permitted to exercise jurisdiction over American nationals under the treaty between the United States and Morocco signed September 16, 1836, and the Act of Algiers signed April 7, 1906, and exercised by custom and usage the same jurisdiction over subjects of Morocco or others who may be designated as protégés under the Convention of the Madrid signed July 3, 1880.
Okay, you see what they just did? Now they're talking about the parties. The parties must be known. So they come right on out and they start to now do what? Confess who they're talking about. They said, we got jurisdiction over who? Subjects of Morocco. Treaty of Madrid, 1880, paragraph 15. Article 15, paragraph 1 says what? Any subject of Morocco that's been naturalized in a foreign country must choose between the entire submission to the laws of the empire. So the subjects of Morocco are still under the jurisdiction of the United States of America. Right? And then they tell you it's by treaty. Then they tell you it's treaties. They say, oh, okay, Treaty of Peace and Friendship, 1836. Right? Then they say, oh, okay, and the Treaty of the Act d'Algeciras of 1906. And the Treaty of what? 1880. Treaty of Madrid, 1880. They point out all three treaties. And then got the audacity to talk about protégés and subjects. Subjects and protégés. Where we find that language at? Treaty of Madrid, 1880. More say, they ain't got jurisdiction over me. Yes, they do. Why am I looking this up? We're talking about principles. But what's the first rule in the principle? Okay, let's go back to it. We're going to finish reading this. What's the first rule in principle? Fundamental truth. which is the foundation of your mental status. Do you have a mental foundation of who you are? That's the first foundation, is you. What are you standing on? More say stand on your square. Okay, you're standing on something. What's the square? It's you. A square is a circle. We're talking principles. So what is the United States of America doing right now? They're setting up some principles of some fundamental truth. They still got jurisdiction over more subjects and proteges, and they're utilizing the law of treaties to set up what? Rules, procedures to still maintain civil and criminal jurisdiction over their more subjects that they've labeled as NAFTAs. Let's finish the reading. Okay, so now that they point out the treaties, they gave them the jurisdiction. Okay, good brother.
Whereas Morocco is now the only foreign country where the Consul of the United States exercise such jurisdiction, and whereas it is the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco at such time as become appropriate.
Pause. They still talking about Morocco. Oh, they fascinated with Morocco. I wonder why. Why do they turn around and say, whereas it is the policy, right, of the United States to discontinue the exercise of extraterritorial jurisdiction? Wait a minute. Did they say the law or did they say the policy? Is policy a law? No. Is policy legislation? No. So when they say policy, they're talking about their policies, codes, and statutes, right? But not even necessarily statutes, but the policy is not law. They tell you right there in your face. They didn't say law. They said, whereas it's the policy of the United States to discontinue the exercise of extraterritorial jurisdiction in Morocco. But at such time that becomes appropriate. Wait, at such time it becomes appropriate. Well, wait a minute. But the Moors were so fast to read. Oh man, see, they approved the relinquishment of consular jurisdiction. See, they can see how they set the Moors up. See, these Moors just read titles, and that's where they stop. Then they skim the rest. They gave you the answer to the test in a body to see if you would read. They gave you the okie doke with the title, but you don't study the title to understand what. You got to keep reading. Listen. Now they continue to tell you the truth. Now they're going to tell you who set up this joint resolution. Go ahead, good brother, speaks.
Resolved by the Senate and House of Representatives of the United States of America and Congress assembled, that the relinquishment by the President at such time as he considers this appropriate of the consular jurisdiction of the United States in Morocco is hereby approved in sections.
Pause. So the Senate and the House of Representatives saying, yo, we cool with you, President, signing off on the bill. So what did the House of Representatives and the Senate do? They got together and put together a joint bill. They handed over to the President and say, you can sign it whatever you want. We've done our job. The International Court of Justice said, what? That we had to do certain things in Morocco to relinquish extraterritoriality jurisdiction. But we can hold on to jurisdiction as long as the Moors keep acquiescing. That was the agreement from the ICJ. So they agreed to relinquish extraterritoriality when the Moors make a proper claim. Then, and only then they turn around and say what? That the relinquishment by the President. Wait, I thought they already relinquished it. They wait on the President to do what? At such time as he considers this appropriate, he can sign the bill and sign it into law. Find appropriate of the consular jurisdiction of the United States in Morocco. So therefore the President can determine when the United States is going to relinquish extraterritoriality jurisdiction because the Moors are no longer acquiescing. We made a demand for our trust to be returned into the hands of a person worthy of trust. That's Article 22 of the Treaty of Peace and Friendship. We must make a demand for our what? Our property, our trust to be returned into the hands of someone worthy of trust. Who's the person worthy of trust? the state. So all of these, okay, good brother, let's pick it up right here so everybody understands. Is hereby approved. Okay, continue right there, good brother.
Is hereby approved in sections 1693, 4083 to 4091, inclusive 4097 to 4122, inclusive, and 4125 to 4130, inclusive, of the revised statute as amended or repealed effective upon the date which the president determines to be appropriate for the relinquishment of such jurisdiction.
Pause. So they said, yes, it's repealed when? Upon what? The date. The date in which the president determines it to be appropriate for the relinquishment of such jurisdiction. It's never been relinquished, Morris. It's been a bill since August 1st, 1956. They refer to it as a policy because it ain't law. Continue, good brother.
Except so far as may be necessary to dispose of cases then pending in the consular courts in Morocco.
Okay. So it was approved August 1st, 1956. ETSEC means go back and look up this case. Go back and look up these provisions. Go back and look up all these codes, 4097, 4122, etc. Go back and look up what? Public Law 856, that's what ETSEC means. Go back and look up the history of the case, the law, the statute, the bill, etc. And it was codified language as 8 Stat 48434 Stat 2905. Why are we reading this? We're talking principles. The principle is what? About fundamental truth. So the United States of America is waiting on Moors to make a proper claim, and then the President of the United States has no choice upon demand from the consular court, because by that way and that way only can you enforce the United States President to relinquish jurisdiction in Morocco. Have the Moors done that? No. ANPAC is in the process of doing that. Right? Okay. What else? Okay. So that's Public Law 856, right? Public Law 856, a lot of Moors are familiar with it. Right? So that was 1956. What happened in 1960? This is principles. So in 1960, the United Nations General Assembly members get together and put together a decolonization documentation to decolonize Morocco and the world for indigenous people. 1960 is the date. 4 years after the United States of America signs a bill that says, yeah, we're going to get back the land whenever the Moors make a proper claim. But the United Nations comes around and says, yeah, we're not necessarily going to agree with that. We're going to enact international law in 1960 that says what? A declaration, the granting of independence to colonial countries and people. So everywhere that there's colonists maintaining colonialism, the indigenous people, i.e. the Moors, could decolonize with a pen. So they enacted a law to the United Nations, according to the International Court of Justice adjudication, their judgment, right? The United Nations picked that case up and enacted this. It says, now we'll create legislation to support the International Court of Justice case of 1952 to allow those Moors to get their land back. Because see, it's one thing for a court to issue a judgment. It's one thing for a court to issue an order. It's one thing for a court to issue an advisory opinion. But what really backs it up? Legislation. Right? Okay, going back to the definition of procedure. We're talking clearer, right? So the principle, United Nations, based upon the fundamental truth of the case of France versus United States of America, 1952, the International Court of Justice came out with a doctrine of Resolution 1514 of the year 1960 that set forth international law, that set up a rule of decolonization, and through decolonization, it now set up the procedures where the Moors, based upon their statehood, can enact civil and criminal jurisdiction against colonizers. You see?
Yep.
These are principles. You got to go back and do your research and read what's commonly known as the Declaration on the Granting of Independence to Colonial Countries and Peoples. Right? We won't read it at this time. It's what? General Assembly Resolution. So, United Nations Resolution 1514 of 14 December 1960. This is chronological order. I'm building up. Okay, that's 1960, after the France versus United States of America. Okay, and after the United States enacted a bill, but they didn't sign it into law. They didn't relinquish jurisdiction. They said, nah, we waiting for the Moors to do it. And the International Court came out and said, no, you're supposed to relinquish. So what did the United States do? See, ain't no such thing as halfway crooks. They're scared to death. They're scared to look. They're scared to death of what? To give the jurisdiction back to Moors. So they put the onus on the Moors. They say, we're going to put the pen right here and say, the Moors can pick it up whenever they want. We'll relinquish when you Moors pick up Excalibur. But in the meantime, y'all ain't doing it, so we're going to have to maintain civil and criminal jurisdiction over y'all, because we got to have some laws that deal with criminals. Because the ICJ gave them the power to maintain a limited coastal jurisdiction over NAFTAs. Okay, so what happens next? 1960. Okay, we're talking principles. We're building up. Keep it germane. We're talking about what? The Charter of the United Nations about what? Human rights. For people who understand their state rights. Okay, we're looking at principles because the United Nations is about what? Let's go back to it so we don't lose our point. Chapter 1 is about what? The purpose and principle. That's chapter 1. So we got to break it down. They're giving you the answers to the test. Go look up principles. And in principles, you got to understand it's all about fundamental truths, about the laws that set up the rules and the procedures of courts to determine a legal dispute. Between who? Moroccans and Americans. Listen, so what happens next? That's 1960, right? Okay, what's this? This is ANPAC's Constitution. February 28, 2021. Why? Because ANPAC's reading, following the instructions of the Acta Algeciras of 1906, Chapter 7, Articles 120 to 123 says, you got to check boxes. And you got to know yourself first, that you're Moroccan. Second, you got to do what? Enact the Constitution. What's the second thing you do? Now you got sovereignty and what? Independence, then you got what? And territorial domains through your courts and laws. That's the second box that ANPAC is on right now. We're on the second box of interior domains of our laws and courts. We're setting up the procedures. We're making rules based upon the law because we understand the fundamentals of self. So what happens next? That we got a constitution. Well, we ratified, deposited, and promulgated, right? We're following the instructions, okay? So what happened? Now, ANPAC, as an example, all the Moors have to do this. Now ANPAC is doing what? Now we're checking boxes. Right? Just like the United States did with all their treaties and all their declarations and all their conventions. We started checking boxes. Right? And after we checked all those boxes, what do we do next? We said, okay, our ratified deposited treaties and our ANPAC Constitution was promulgated via competent council court decree against the United States of America and the United States on March 15, 2022. Number 9, decolonization is in full progress, forward motion, in conformity with international law, the principles of law, and the general provisions, foresight, forward motion of Chapter 7 of the Acta Algeciras with ANPAC's Udi Posidatus jurisdiction and throughout the Empire of Morocco. So what did ANPAC do? We're following instructions, right? Because the International Court of Justice on page 202 of the judgment said you had to do what next? You have to enforce your rights through what? Consular court. And by that way, and that way only. So what did ANPAC do next? We issued a consular court order. Right? Okay. This is ANPAC's order from its consular court. It was a Lodian Morris Praedium, Monte, Colorado, consular court of the state, capital S. A provincial state government under the existing and pre-existing sovereignty of the Moroccan Empire, not the American Empire. Moroccan Empire says what? Case concerning treaty rights of Moorish nationals in Morocco. A Lodian Morris Praedium, Monte, Colorado, against the United States of America, the United States, and the state of Colorado. Order of March 15, 2022. 2022. That was the order that went out. Okay? Now this is just basically the cover page. I'm not going to go through it. But the order's been sent out. We're checking boxes. Right? These are the principles. Because we understand the fundamental truth of self. Then after that, we enacted what? We understood what after that? The law and the procedure that set up what? The legal determination through consular court and the state. Let's go back to principle. So under our principles, our fundamental truth, set up the laws, the rules, and the procedures to get our legal determination of self. So your legal determination about self-determination. Of who? Moroccans. Are we ready now to read chapter 1? I tell you what, we're going to pick this up in class 79. Now that we understand the definition of principles. I end with that. Islam.